So let's talk about this scenario. And it's just a scenario, I'm not giving legal advice, we're just talking about a scenario. If you had a dad who divorced your mum and dad repartnered and had been with his de facto partner with 20 years, dad's now died. Does the de facto partner, your stepmum, get all of dad's estate? My name is Jess Burke. I am an Australian wills and estate solicitor and a founder of Wills No Frills, which is a will drafting service. So I've created a diagram that I'll show you. So in New South Wales, when you die without a will and you die intestate, the Succession Act sets out who is entitled to your estate and in what amounts, percentages. In the scenario where you have a stepmum and also a child from a previous relationship, then the de facto stepmum gets a statutory legacy. So the de facto gets a set amount from the estate. Now I've put $482,000, but the statutory legacy actually changes and it's based on a CPI calculation. So the de facto would get likely more than $482,000 and they'll get half of everything else. They also get the personal assets in the property. So they'll get like all the sentimental personal items of the deceased. But what about the child of a previous relationship? What do they get? The child will get half of whatever's left. So if the estate's relatively big, then the step parent or de facto will get $482,000 in personal effects and half of anything else, and the child of a previous relationship will get half of whatever's left. But if the estate's quite small and the estate's worth less than $482,000, then what that means is the de facto gets everything and the child gets nothing. Or say if the estate was worth $600,000, then the de facto is getting the lion's share of the estate because they're getting $482,000 and then half of whatever's left, which leaves the child of a previous relationship with not much if the estate's only worth like $600,000. Now, what happens if there's more than one child? So if this child had siblings, then half of whatever's left is just divided between all the children. So like this. So the children would get half of the residue divided equally between the children. Now, the other interesting thing to think about that we don't know in this scenario is the ex-wife. They're divorced, but did they have a family law property settlement? If they did not do a family law property settlement by way of getting some sort of court orders or a binding financial agreement, then the ex-wife might also be entitled to some part of the deceased estate here. Then let's also say, what happened if the de facto and the deceased also had children of their own? So if the de facto or your stepmom and your dad, the deceased, had their own children, then those children wouldn't receive anything under the intestacy rules. It's just the de facto and children from a previous relationship in this scenario who would receive. So I hope that helps you with this scenario. Please get specific legal advice and financial advice if this is more than just a scenario for you. The Succession Act sets out what happens if you die without a will, but you can challenge that as well. If you're not happy with what this sets out under the legislation, then people can make family provision claims when people die without a will as well. I hope this scenario really points out how important it is to do some really proper estate planning if you have a blended family or children from a previous relationship. You can see that your children from a previous relationship can end up with not much if your estate is quite small because of the statutory legacy that's paid to your de facto partner. This scenario also pinpoints how important it is to do a family law property settlement with any ex-wives or ex-husbands to ensure that they can't claim on your estate. So it's one thing to get divorced, but that just ends your marriage. You need to do a property settlement as well that ends your financial relationship. And just a shameless plug at the end, Wills No Frills creates simple wills. It does have options for blended families or if you have children from a previous relationship. It's more than capable of creating a simple will for this kind of family dynamic. We currently have a sale on where we're offering $90 to do a will, and you can get started by clicking the link in the bio or heading to our website. Every will done with Wills No Frills will be checked, drafted and reviewed by an Australian qualified solicitor such as myself.